time is 1:00 p.m.
Okay, let us discuss partnership dissolution. Okay, now what do you mean by dissolution? Under Article 1828 of the Civil Code, sabi dyan, the dissolution of a partnership is the change in the relation of the partners caused by any partner ceasing to be associated in the carrying on as distinguished from the winding up of the business. Kaya once nagkaroon ng change in relation among the partners, okay, then it would cause partnership dissolution. Like for instance, okay, debt. Okay, kunwari, ang partners is ABC, later on A die, okay, kaya lumalabas there are now two partners. Kasi before there are three partners, ngayon dalawa na lang. Kaya nagkaroon ng change in relation among the partners. Or pwede ring class na ABC nag-form ng partnership for a fixed term of 5 years. Upon arrival of the term, automatic the partnership is dissolved. Yun nga lang, pag kinontinue nila, okay, magiging partnership at will na siya. And therefore, pwede siyang i-terminate at any time, okay, without breach of contract. Or another, A, B, C are partners, A, withdraw. In that case, magkakaroon ng change in relation among the partners. Kasi before, there are three partners, ngayon, dalawa na lang. Kaya any change in relation of the partners, yun nga, caused by any partner ceasing to be associated in the carrying on of distinguished from winding up of business. Kaya take note, okay, pag nagkaroon ng partnership dissolution, change in relation lang, but not necessarily okay, magwa-wind up. Okay, kasi pwede pa rin siyang i-continue ng remaining partners. Okay, kasi pag sinabing winding up of business na, okay, it means, okay, we are now selling partnership property. Okay, magkakaroon ng payment of partnership creditor and the distribution of surplus, if any, okay, to the partners. Kaya meron kayong tatlong tatandaan na terms dito. Okay, first, yung tinatawag na dissolution. Second is the winding up. And last is the termination. Kaya tandaan nyo, pag sinabing dissolution, change in relation among the partners. Okay? Pag sinabi ng winding up, okay, ito yung process of selling non-cash asset. Okay? Payment of partnership creditor and distribution, okay, of the surplus, if any, among the partners. Pag sinabi naman termination, ito yung point in time wherein the winding up process is already completed. Now, under 1829, sabi dyan, on dissolution, the partnership now is not terminated, okay, but continues until the winding up of partnership affairs is completed. Okay, kasi pag sinabi ng dissolution, I repeat, change in relation lang. Kaya not necessarily terminated siya. Magkakaroon siya ng continuation until magkaroon ng winding up, okay, ng partnership, okay, affairs daw is completed. Okay, ngayon, meron tayong dalawang klaseng dissolution. Yung automatic, sa kaya tinatawag na judicial. Okay, now these are commonly asked questions in the CPA board exam. Okay, papa-identify sa inyo whether this is automatic, okay, or judicial dissolution. Kaya dapat, okay, familiar kayo what are, okay, those ground for automatic dissolution, saka ano naman yung grounds for judicial. Okay, pero by the way, ito lang yung rule of thumb natin. Okay, pag wala siyang judicial controversy na kailangan i-settle ng court, then ground yan for automatic. Pero kung meron siyang controversy na kailangan i-settle ng court, okay, in that case, ground yan for judicial. Okay, now isa-isahin natin yung ground for automatic dissolution. Bali, number one, without violation of agreement between the partners. Meaning, wala tong breach of contract. Letter A, by termination of the definite term or particular undertaking is specified in the agreement. Kasi halimbawa, si ABC, nag-form sila ng partnership with a fixed term of 5 years. Okay? Kaya once nag-arrive yung term niya, then automatic, the partnership is automatically dissolved. Dissolve agad rito yung partnership with a fixed term. Or Okay, pwede ring partnership with specific undertaking once na-complete nyo yung specific undertaking. Pero take note, pag kinontinue nung partners yung operation nung partnership, automatic mako-convert siya into a partnership at will. Pero yung partnership with a fixed term is now dissolved. Pero walang breach of contract dito. Okay? Kaya lumalabas kung na-convert niya sa partnership at will, pwede na siyang i-dissolve at any time without committing a breach of contract. Okay, yung letter B, by the express will of any partner who must act in good faith when no definite term or particular is specified. Example, ABC, nag-form sila ng partnership at will. Okay, later on, okay, si A nag-withdraw. In that case, the partnership is automatically dissolved. Pero take note, walang breach of contract. Kasi nga, partnership at will siya. Kaya pwede siyang dissolve at any time. Provided the withdrawing partner must be acting in good faith. Letter C, by the express will of all partners who have not assigned their interest or suffered them to be charged for their separate debts, either before or after the termination of any specified term or particular undertaking. Example, ABC, they form a partnership, okay, with a fixed term of 10 years. Okay, after 3 years, all of them decide, okay, to dissolve the partnership. In that case, the partnership is dissolved, but there is no breach of contract. Why? Because all the partners agree to dissolve it. Kaya walang breach of contract. Yung letter D naman, by the expulsion of any partner from the business bona fide in accordance with such power conferred by the agreement between the partners. Kaya halimbawa, si ABC, okay, are partners of ABC partnership. Okay, later on si A was expelled from the partnership, okay, pursuant to the agreement, okay, between the partners. Okay, in that case, the partnership is dissolved pero walang breach of contract. Okay, kasi nga yung nakalagay dito, in accordance siya with the power conferred by the agreement between the partners. Kaya ibig sabihin kung expulsion niya, magkakaroon ng change in relation among the partners, but the expulsion is through the agreement among the partners, that's why walang breach of contract. Now, tingnan mo yung number 2, in contravention of agreement between the partners where the circumstances do not permit a dissolution under any other provision of this article by express will of any partner at any time. Example, now ABC are partnership of ABC partnership, okay, for a fixed term of 10 years. After 3 years, A decide to withdraw. Now, in that case, the partnership is automatically dissolved. Pero, may breach of contract. That's why A is liable for damages. Kasi lumalabas, nag-withdraw siya, hindi pa nag-a-arrive yung fixed term. Kaya liable siya for breach of contract. Okay, kaya papasok yun sa number 2 kasi in contravention yan ng agreement between the partners. Okay, now sa number 3 naman, any event daw which make it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership. Now, minention ko to before. Sabi ko pag ang object ng partnership is unlawful from the very beginning, then the partnership is null and void. Non-existing partnership siya. Pero pag ang object ng partnership is lawful from the beginning but subsequently it becomes unlawful, then ground lang yan for automatic dissolution under Article 1830, paragraph number 3. Okay? Or nakalagay diyan, or for the members daw to carry it on in partnership. Kunwari, ABC are partners of ABC partnership and this is a law firm. Okay, later on, A was appointed as RTC judge. That's why he's no longer allowed to, okay, represent his client in court. That's why in that case, okay, magkakos din siya ng dissolution. Kailangan niya mag-withdraw sa partnership. Okay, number 4, when a specific thing which a partner had promised to contribute to the partnership perishes before the delivery, in any case by the loss of thing, when the partner who contributed it having reserved the ownership thereof has only transferred to the partnership the use or enjoyment of the same, but the partnership shall not be dissolved by the loss of thing when it occurs after partnership has acquired the ownership thereof. Okay, now, yung number 4, ulitin ko lang yung rule. Pag ang partner kasi ay nag-promise na mag-contribute, na mag-deliver ng determinating, wherein ownership will be transferred to the partnership upon delivery. Pag na-loss yan before delivery, the partnership is automatically dissolved. Kasi ang reason, lack of capital contribution because determinate object. Hindi siya pwedeng i-replace ng another thing. Okay, pero kung halimbawa, na-loss yan after delivery, then the partnership is not dissolved. But the partnership will suffer the risk of loss because ownership is already transferred to the partnership. Okay, however, if a partner promised to contribute a determinate object wherein only the use will be transferred to the partnership. Okay, ibig sabihin hindi malilipat yung ownership sa partnership upon delivery. Ngayon, pag na-loss yan either before or after delivery, ground yan for automatic dissolution. Kasi ang reason dyan is lack of capital contribution pa rin. Kasi nga, yung ownership ng thing, ni-retain ng partner. Kasi ang ililipat lang niya sa partnership is only the use of the thing. Okay, yung number 5 is death of any partner. By the way, I think yung death kasi under the law kasi there are two kinds of death. May tinatawag na actual death saka yung presumptive death. Okay, in my opinion, yung death of any partner dito, I'm referring to actual death, not presumptive death. Kasi pag presumptive death, kailangan ng judicial declaration yan. Okay? Another is insolvency of any partner or the partnership. By the way, dalawang binanggit dito, insolvency ng any partner or pwedeng ang naging insolvent yung mismong partnership. Kasi yung partnership, meron siyang juridical personality, separate and distinct from the partners composing it. And of course, last is civil interdiction of any partner. Kaya once yung partner was civil interdicted, okay, ground dyan for automatic dissolution. Okay, now, by the way, pag sinabing civil interdiction, minsan tinatawag siyang civil debt kasi nalilimit yung capacity niya to act. Kaya halimbawa, nakakommit kayo ng offense where the penalty imposed by law is reclusion perpetua to death. Okay, then, normally, yung penalty under the law, meron siyang accessory penalty of civil interdiction. Kaya once na-convict ka dun at may accessory penalty of civil interdiction and you are a partner, then ground dyan for automatic dissolution. Kasi pag ikaw ay civil interdicted, nalilimit ang capacity mo to act. Kasi pwede ka na lang mag-dispose ng property inter vivos, but not, okay, bawal ka na mag-dispose ng property inter vivos on the mortis causa transfer. Okay, punta naman tayo sa judicial dissolution. Manonotice mo sa judicial dissolution, meron siyang controversy na kailangan i-settle ng court. Kung may issue, okay? Kasi halimbawa, may allegation ka, sabi mo, baliw yung partner na yan. Sabi naman niya, hindi po, malapit pa lang, di ba? Kaya yan, kailangan i-settle siya ng court. Kailangan may judicial declaration na siya ay already of unsound mind. Okay, sabi ko itong partner na to, laging nagko-commit ng breach of partnership agreement. That is an allegation. Kailangan i-prove mo siya. Kaya dito, kailangan i-prove. Kaya ibig sabihin, mayroong certain controversy na kailangan i-settle ng court. Now, unang mapapansin nyo sa grounds number 1 natin, partnership has been declared insane. Kaya yung insanity, hindi yan ground for automatic dissolution, but rather ground for judicial. Kasi kailangan may judicial declaration that a person, okay, is already of unsound mind. Okay, number 2, a partner become incapable of performing his part of partnership contract. Kasi diba, ang allegation ko si A na partner, incapable siya na i-perform ang kanyang duty in a partnership contract. That is an allegation. Okay, pwede niyang i-rebut to. That's why ground dyan for judicial. A partner has been guilty of such conduct as tend to affect prejudicially the carrying on of the business. A partner willfully or persistently commit a breach of partnership agreement or otherwise so conduct himself, okay, in a matter relating to the partnership business that it is not reasonably practicable to carry on the business in partnership with him. The business of the partnership can only be carried on at a loss. And of course, number 6 is other circumstances rendered a dissolution equitable. Okay? Now, on the application of purchaser of partner's interest under Article 1813 or 1814. Kasi halimbawa, ang question dito. Okay, sino bang pwedeng mag-file ng petition for judicial dissolution? Okay, so of course, ang rule is any partner. Okay, can file a petition for judicial dissolution on that ground. Okay, pero meron pa eh. Sino? Yung assignee of interest. Sino ba yung assignee of interest? Okay, di ba sabi ko sa inyo, halimbawa, partner ako, may 30% interest ako sa firm. Okay, at pwede ko ba siyang i-transfer? Yes. Okay, pero hindi siya magiging partner unless may consent ng all partners. Okay, tawag sa kanya assignee of interest. Pwede ba siya mag-file ng petition for judicial dissolution? The answer is yes. Pero at a proper time. Now, ano ibig sabihin ng proper time? Kung ang partnership is with a fixed term or particular undertaking, okay, he need to wait until arrival ng period or accomplishment ng purpose. Pero kung halimbawa yan ay partnership at will, pwede siyang mag-file ng petition for judicial dissolution at any time. Okay, kaya itong number 1, okay, ito applicable to sa partnership with a fixed term or particular undertaking. Kaya nakalagay dyan, after termination of the specified term or particular undertaking. Or pangalawa, okay, ito naman partnership at will. At any time, if the partnership, okay, was a partnership at will when the interest was assigned or when the charging order daw was issued. Okay, now, ano ba class ang legal effect ng dissolution? Okay, simple lang ang effect ng dissolution. Sabi ng batas, when the partnership is dissolved, it terminates the authority of any partner to act in behalf of the partnership. Kaya ibig sabihin, yung mutual agency dito, mata-terminate siya. Kaya ibig sabihin, okay, once na dissolved to, okay, kumbaga, extinguish yung agency. Kasi tandaan niyo yung partnership is just a species of agency. Kaya di ba yung death ng principal or agent, ground dyan for extinguishment ng agency. Kaya dito naman kung na-dissolve na yung partnership, mata-terminate yung authority ng any partner na mag-act in behalf of the partnership. Pero by the way, meron kayong dalawang issue na kailangan i-settle dito. Okay, ang first issue na i-settle natin, okay, when a partnership is dissolved, di ba basic premise natin, when the partnership is dissolved, it terminates the authority of any partner to act in behalf of the partnership. Pero ang question dyan, okay, can a partner still bind the other partner after dissolution? Yun, question mark yun, di ba? Yun yung una. Second, can a partner bind the partnership after dissolution? Okay, yan yung second issue. By the way, magkaiba yung sagot dyan kasi remember, yung pinag-usapan natin before, iba ang relationship among the partners. Iba rin ang relationship pagdating sa third person. Kaya unahin natin yung relationship among the partners. Can a partner bind the other partner after dissolution? Okay, etong rule. Okay, sabi ng batas, okay, general rule ha, balikan ko lang, dissolution terminates all authority of any partner to act for the partnership. Okay, kaya tandaan nyo ha, once yung partnership dissolved na, mata-terminate yung authority ng any partner na mag-act in behalf ng partnership. Pero sabi yan, except so far as may be necessary to wind up partnership affairs or to complete transaction begun but not then finished. Now, ito yung number 1 na sinasabi ko sa inyo. Yan yung relationship among the partners. Ito naman, yung relationship pagdating sa third person. Ngayon, sabi ng batas, dun sa letter A, when the dissolution is not by the act, insolvency, or death of a partner. Kaya ibig sabihin, i-distinguish ninyo yung grounds ng dissolution. Kasi pag ang grounds ng dissolution is aid, okay? O kaya, ang ground ng dissolution is other than aid. Ano ba yung aid? Yan yung act, insolvency, saka death. Okay? Ito yung tinutukoy dyan, when the dissolution is not by the act, okay, insolvency or death of a partner. Ito naman, when the dissolution is by such act, insolvency or death of a partner in cases where Article 1833 so requires. Okay, kaya tandaan nyo ha, pag ang grounds daw ng dissolution is aid, tandaan nyo ha, aid, act, insolvency, saka debt. Okay, mapapansin mo, pag act, kailangan ng knowledge. Pero pag insolvency or debt, pwedeng knowledge or notice lang. Kaya ibig sabihin, kung halimbawa, yung partner for instance, namatay. Okay? Bawa, ang partners is A, B, and C. Later on, si C namatay. Sabi natin yung death ng any partner is a ground for automatic dissolution. That's why, okay, once na-dissolve yung partnership, mag-determinate yung authority ng any partner na mag-act in behalf of partnership. Ang problema, si A, hindi niya alam na patay na pala si C. Wala siyang knowledge, actual knowledge, nor notice that C is already dead. Ang question, pwede bang i-bind ni A si B saka yung estate ni C? The answer is yes. Sapagat ang ground ng dissolution is death. Now, since wala siyang knowledge or notice ng death, therefore, pwede pa rin niyang i-bind si B at yung estate ni C. Or let us modify. Sabihin natin, class, na ang ground ng dissolution is insolvency. Siyempre, kung bawa si A, si C, naging insolvent, hindi alam siyempre ni A yan. Kasi, paano niya malalaman yung personal finances ni C? Kaya kung wala siyang notice or knowledge ng insolvency ni C, it means A can still bind B and C. Okay? Pwede niyang i-bind ngayon si B saka si C kung wala siyang notice or knowledge ng dissolution. Or another example is act. ABC are partners of ABC partnership. Later on, si C nag-withdraw sa partnership. Di automatic dissolve siya kasi magkakaroon ng change in relation among the partners. Pero si A, wala siyang notice or knowledge ng withdrawal ni C. Kaya ang question, can A still bind B and C? The answer is yes. Kung wala siyang knowledge ng withdrawal. Okay? Okay? Balikan ko, ulitin ko lang. Okay? Basta, pag ang ground ng dissolution ay act, insolvency or debt, pagdating sa act, wala kang knowledge. Pag insolvency or debt, wala kang notice or knowledge ng insolvency or debt, a partner can still bind the other partner. Pero may nakalagay tayong note na not only actual knowledge, but only knowledge of such other facts amounting to bad faith. Kaya ibig sabihin yung tinutukoy ko dito, na knowledge, either actual or knowledge of such fact, amounting to bad faith. Now, paano pag halimbawa ang ground ng dissolution is other than aid? Pag ang ground ng dissolution is other than aid, bumalik ka doon sa general rule. In no case can a partner bind the partnership. Kaya nakalagay dyan ha, the authority of any partner to bind the partnership by a new contract is immediately terminated. Kaya basically, example lang. Halimbawa, ang ground ng dissolution ng partnership, for instance, is the object of the partnership becomes unlawful. Then the partnership is dissolved, automatic dissolved. In that case, a partner can no longer bind the other partner sapagkat ang ground ng dissolution is other than aid. Ngayon, punta naman tayo dun sa relationship pagdating sa third person. Kaya kung babalik tayo dito, ang question is, can A bind the partnership after dissolution? O yan yung issue na kailangan nating i-settle. Kasi lumalabas, relationship siya pagdating sa third person. Ngayon, ang sabi dito sa batas, after dissolution daw a partner can bind the partnership. Aba, ang gandang rule. Ibig sabihin, pag ng partnership dissolved na, pwede pa raw i-bind ni A ang partnership. Okay, pero naka-qualified yan. Tingnan nyo ha. Number 1, by any act appropriate for winding up partnership affairs or completing transaction unfinished at dissolution. Kaya ibig sabihin kung halimbawa si A for instance dito is a liquidating partner at yung transaction niya sa third person is necessary for winding up of partnership affairs binding. O kaya to finish lang unfinished business at dissolution. Tapos pangalawa, by any transaction daw which would bind the partnership if dissolution had not taken place. O ano ibig sabihin yan? Kung wala daw dissolution, pwedeng i-bind daw ni A yung partnership. Sabi mo, sir, ano ba yung instance na pwedeng i-bind ng partner ang partnership, di ba? Kung walang dissolution. Balikan mo yung rule na binanggit ko sa inyo before. Sabi natin, para ma-bind ng partner ang partnership, there are 2 requirements. Number 1, the partner must be duly authorized, whether express or implied. Or number 2, okay, dapat nakipag-transact siya sa third person, not in his own name, but in the name of the partnership. Pag present yung dalawang requirement na yan, that is actually transaction between partnership and a third person. Kaya yung tinutukoy ko dito, okay, na if dissolution had not taken place, it means the transaction must in the ordinary course of business. Kasi kahit wala kang express authority, pero may tinatawag tayong apparent authority. Kaya yung tinutukoy ko dito, ordinary in the course of business ng partnership. Tapos letter A, sabi dyan, had extended credit to the partnership prior to dissolution and had no knowledge or notice of the dissolution. Ano bang ibig sabihin ng extended credit? It means hindi ito first time transaction. Kasi halimbawa, si A is a managing partner. Okay, nakipag-transact siya, okay, sabi natin kay B, a third person. Pero supplier to ng partnership for the past 5 years na. It means si D has already extended credit to the partnership prior to dissolution. Okay? Kaya lumalabas kung si D ay walang knowledge or notice ng dissolution, it means yung transaction dito ni A with D binding sa partnership yan. Ano naman yung letter B? Sabi diyan, though he had not so extended credit, had nevertheless known of the partnership prior to dissolution, and having no knowledge or notice of dissolution, the fact of dissolution had not been advertised in a newspaper of general circulation in the place at which the partnership business was regularly carried on. Kaya ibig sabihin, yung tinutukoy ko dito sa letter B, okay, first time transaction. Halimbawa si A, okay, dissolve na yung partnership. Nakipag-transact siya kay D. Pero ito ay first time transaction. Pero si D may knowledge ng existence ng partnership. Ngayon, pag itong si D daw ay walang notice or knowledge, okay? Wala siyang actual knowledge or notice ng dissolution. Kasi hindi naman yan pinablish sa newspaper of general circular. Okay? Now, in that case, halimbawa, hindi naman nabasa for instance. Okay? Walang actual knowledge si D. Hindi rin niya nabasa sa newspaper of general circular. Okay? It means, okay, binding siya sa partnership. Pero may na-notice ka ba? Doon sa distinction doon sa paragraph A and B. Kasi doon sa paragraph letter A, kailangan dito ng notice or knowledge. Okay, dito, sufficient na yung publication sa newspaper of general circulation. Okay? Now, okay, next, punta tayo dito. The partnership daw is in no case bound by any act of partner after dissolution. Sabi mo, sir, sandali. Hindi ba ito conflict? Sabi mo kanina, okay, yung partner, pwedeng i-bind yung partnership after dissolution. Dito naman ang sinasabi, hindi raw pwedeng i-bind ng partner ang partnership after dissolution. Answer, walang conflict. Ang sinasabi lang dito, hindi na pwedeng i-bind ng partner ang partnership after dissolution if number one, okay, when the partnership daw is dissolved because it is unlawful to carry on the business. Ibig sabihin, pag ang ground ng dissolution is that yung object ng partnership naging unlawful, then a partner cannot bind the partnership. May exception na naman dun. Okay, unless of course, necessary yan for winding up of partnership affair. Kasi halimbawa, ang ground ng dissolution is yung object ng partnership, okay, becomes unlawful. Di lumalabas, dissolved. Kaya dapat hindi pwedeng mabind ng partner ang partnership. Eh ang problema, si A kunwari na partner is a liquidating partner. Yung transaction niya sa third person is necessary for winding up of partnership affairs. Binding yan sa partnership. Number two, when the partner daw has become insolvent. Kaya pag ang ground ng dissolution, insolvency ng partner, hindi mo pwedeng i-bind yung partnership. And number three, when the partner has no authority to wind up partnership affair. Kaya ibig sabihin, kung hindi ka liquidating partner, ang rule, hindi mo pwedeng i-bind ang partnership. But may exception na naman. Kasi sabi dyan, except by transaction with one who, okay, ito yung tinutukoy ko, yung transaction ay ordinary in the course of business. Tapos doon sa letter A, ito, kunwari supplier yan ng partnership for the past 5 years na, kaya nag-extend na ng credit yan. At yung third person, walang notice or knowledge ng dissolution, binding sa partnership. Pero kung first time transaction siya dito, wala raw notice, walang knowledge, walang publication sa newspaper of general circular. Okay, in that case, okay, binding pa rin siya sa partnership. Now, problem. Okay, ito, nilist ko lang tong problem na to sa book ni Soriano. Okay, tingnan natin. Okay, Sibal, Untalan, Parefio, Eusebio, and Ranis are partners of Super Enterprises whose business is car painting and repairs. Pakicheck nyo plus maigi yung operation. Kaya ibig sabihin, ang business ng partnership is car painting and repairs. All partners are capitalist partner with Sibal as manager. Now, after 5 years of operation, Ranis resigned from the partnership. Eh, di ba ang resignation, ground dyan for automatic dissolution. Sabi yan, although Sibal was aware of the resignation of Ranis, he still bought 50 gallons of car paint from Master Paint owned by Marcelo, who had been dealing with Super for the past 5 years. Now, may question lang ako sa inyo dito. Relevant ba dito yung si Sibal, aware siya sa resignation ni Ranis? Answer, relevant yan dun sa relationship among the partners. Kasi technically, dapat hindi na pwedeng i-bind ni Sibal yung other partners like Untalan, Parefio, Eusebio, and Ranis. Okay, why? Eh kasi aware siya, may knowledge siya. Okay, nung resignation. Kaya kung may knowledge siya nung resignation, dapat hindi niya pwedeng i-bind yung other partners. Pero irrelevant yan pagdating sa third person. Kasi iba yung rule natin sa third person. Tama? Kaya sabi dito, okay, despite na dissolved na yung partnership, he bought daw 50 gallons of car paint from Master Paint, owned by Marcelo, who had been dealing with Super for the past 5 years. Kaya ito nag-extend na ng credit si Marcelo sa partnership. Kasi hindi yan first time transaction. Tapos, and car spare parts from Supreme Parts owned by Salviejo was transacting for the first time with Super. Kaya hindi pa siya nag-extend ng credit sa partnership. The dissolution of Super daw was published in the Manila Bulletin, but neither Marcelo nor Salvejo read it. Neither one knew at the time they transacted with Sibal that the partnership had been dissolved. Now, ang question or issue dito, alin dito yung transaction ni Sibal na binding pa rin sa partnership? Okay, yung unang transaction, okay, with Master Paint owned by Marcelo, hindi yan binding sa partnership sapagkat walang okay knowledge or notice yung third person. Pero yung transaction with Salviejo, okay, which is the owner of Supreme Parts, okay, hindi na siya binding kasi sufficient na yung publication sa newspaper of general circular. Kasi this is a first time transaction. Kaya ibig sabihin, hindi pa nag-extend yung third person ng credit sa partnership. Kaya dito, lumalabas ang sagot natin, ang binding lang ay yung kay master paint. Kaya ang sagot is letter. Pero by the way, class, paki-check nyo lang maigi sa problem. Baka later on may modify, but almost same naman yung concept. Kung halimbawa yung transaction na in-entered dito, for instance ni si Bal, okay, ay hindi naman okay paint or okay repair items. Okay? Now, ibig sabihin, hindi siya ordinary in the course of business. Huwag ka na mag-isip. Kasi siguradong hindi yan binding sa partnership. Because even if there is no dissolution, hindi siya binding sa partnership. Kasi wala naman siyang authority express, wala rin siyang authority implied. Sapagat kung hindi siya ordinary in the course of business, it means wala kang apparent authority. Now, may question ulit ako dito. Okay, ang question ko is, di ba alam nga ni si Bal na nag-resign na si Renis? Irrelevant yan. Kaya ang recourse dito, class, nung third person which is master paint, i-exhaust niya lahat ng asset ng partnership. Pag na fully exhaust na, then to make all partners liable pro rata, including Untalan, Parefio, all of them. I-divide siya ng 1, 2, 3, 4, 5. Okay? Kasi, nabind pa rin yung partnership. Pero since si Val has knowledge of the resignation of Ranis, di dapat hindi na pwedeng i-bind ni si Val si Untalan, Parefio, Eusebio, Ranis. Kaso naging binding sa third person. Kaya pwedeng habulin ni Untalan, Parefio, Eusebio, Ranis, si Sibal. Okay? Pero yan is among the partners. Pero dito kasi, ang tinatanong is with respect to stranger. Kaya ang sagot natin is letter B. Okay? May nakalimutan ako isang slide rito. Pakita lang natin. Okay, general rule class, the liability of a partner shall be satisfied out of partnership asset alone daw. Okay, ibig sabihin, isa-satisfied lang daw yung liability out of partnership asset when such partner had been prior to dissolution daw unknown as a partner to the person with whom the contract is made. Okay, di ba pag unknown ka, edi secret ka. And so far unknown and inactive, it means you don't participate in the management. Kaya lumalabas silent ka. Secret ka na, silent ka. That's why ang tinutukoy dito, I'm referring to a dormant partner. Ibig sabihin, kung isa kang dormant partner at yung other partner, kunwari na bind yung partnership after dissolution, liable ka rin. Pero, isa-satisfy lang out of partnership asset. Kasi example lang, ang partners kunwari is A, B, C, tapos si D. Wherein D is a dormant partner. Ang problema si A, na-bind niya yung partnership after dissolution. Ngayon, ang recourse ng third person, ubusin yung asset ng partnership, pag na-fully exhaust na, then yung balance, i-divide lang ng 3. Hindi divided by 4. Hindi kasama si D na magiging liable pro rata. Kasi nga, dormant partner siya. Okay? Isa-satisfied lang siya out of the partnership asset lang. Okay? Now, let us proceed now dito. Ito, walang kwento naman provision to. Rescission of partnership contract. Sabi, right of party to rescind the partnership on the ground of fraud or misrepresentation. Tatlong remedies ng partner dito. Lien, subrogation, and indemnification. Okay, now, right where dissolution, not in contravention of agreement. Ibig sabihin ang tinutukoy ko dito, walang breach of contract. For example, si ABC are partners of ABC partnerships. Okay? Tapos, later on, kunwari partnership at will to. After 2 years, si A nag-withdraw. Anong effect? Dissolve. Second question, meron ba siyang breach of contract? Answer, no. Wala siyang breach of contract. Why? Kasi partnership at will yan eh. Kaya since walang breach of contract, walang guilty party. Kaya ang right ni ABC pare-parehas lang. Anong right ni ABC? All of them, number 1, can demand, okay, na gamitin yung partnership property pambayad ng partnership obligation. Ngayon, kung meron mang surplus if any, then i-distribute among the partners. Ngayon, sabi mo, sir, paano kung may breach of contract? O punta tayo doon sa pangalawa, ito may breach of contract. Example, halimbawa si ABC are partners of ABC Partnership. Nag-form sila ng partnership for a term of 5 years. Ang problema, after 2 years pa lang, si A nag-withdraw. Anong effect? The partnership is dissolved. Pero A is liable for damages. Kasi may breach of contract on the part of A. Ang innocent party, si B, saka si C. Kaya syempre ang tanong mo dito, sir, ano po ang right ni A? Ano yung right ni B and C? Okay, unahin natin yung right ni B and C. Ito yung innocent party. Una, okay, meron daw silang right na mag-demand na gamitin yung partnership property pambayad ng partnership obligation. Pangalawa, dapat i-indemnify sila ni A for damages. Kasi may breach of contract sa part ni A. Tapos letter C, okay, pwedeng i-continue daw ni B and C yung partnership operation. Either silang dalawa lang na si B lang or magsama sila ng iba tulad ni D, a stranger. At meron daw silang right na i-possess ang partnership property kung nag-decide silang i-continue ang partnership operation. Sabi mo, sir, ano po yung right naman ni A? Yung guilty partner. Okay, it depends. Iko-continue ba yung partnership or ililiquidate? Now, let us assume na yung business is not continued, meaning ililiquidate natin. Okay? May right din siyang mag-demand na gamitin yung partnership asset para ibayad sa partnership obligation. Second, entitled ba siya for the surplus? The answer is yes, after deducting damages. Paano kung i-continue? Pag nag-decide si B and C o yung remaining partner na i-continue yung partnership operation, meron siyang right na mag-demand na bayaran siya ng kanyang interest, either bayaran in cash or secured ng bond approved by the court. At next, pwede siyang mag-demand na i-release na siya sa all existing and future liabilities ng partnership. Okay? Now, ito, gawa tayo ng separate. Okay, video ulit dito. Okay, break muna kayo.